Okay.
All right, thank you. Welcome all to beautiful downtown San Diego. Douglas, can we start with roll call, please?
Thank you, Madam Chair. Commissioner Bradshaw. Commissioner Cruz. Commissioner Falcone,
Here.
Commissioner Grisby. Present. Vice Chair Guardino. Commissioner Lugo,
Here.
Commissioner Liu,
Here.
Commissioner Martinez. Commissioner Norton,
Present.
Commissioner Tavoloni. Chair Eager,
Here.
Senator Newman. Assemblymember Friedman. Madam Chair, we have a quorum.
Thank you, sir. Shall we do some instructions?
Yes, we shall. Welcome to the Transportation Commission Training Workshop. The CTC exists to make transportation planning, funding, and policy more understandable and accountable. Our workshops can take place in diverse locations around the state, and we now offer hybrid and fully virtual workshops to allow our stakeholders to participate more fully no matter where you are. The workshop agenda is located on our website at www.catc.ca.gov. Live closed captioning is available on this webinar. Please select the Show Captions tab at the bottom of your screen. There are a number of language options available there to choose from. Any document the CTC creates can be translated into any language you need. Simply email us at ctc@catc.ca.gov and we'll have them returned to you as quickly as possible. For all of our workshops, we encourage interaction with our stakeholders. There will be an opportunity for comments at the end of this workshop. For those attending via Zoom, you should see the webinar control panel likely located on the bottom of your screen. There you'll find the raise hand and Q&A tabs. We encourage you to use the raise hand feature as soon as we reach that item to give the system time to acknowledge you. Commission staff will let you know when it's your turn to make your comment. Alternately, you may use a Q&A tab to submit your comment or questions. Commission staff will read that on your behalf. As a reminder, each registered attendee is provided a unique link or phone number to access the webinar. These should not be shared with other participants as this can create confusion for staff when making comments. Please do your best to be concise. Please make sure that your comments add new information. If you agree with the comments of a previous speaker, simply make that statement. Thank you for joining us today.
Thank you, Douglas. And we want to say a special thank you for the CTC staff. I know we threw this at you saying that we have some new commissioners that hadn't had training before. So we thought this would be the perfect location to start a little bit early and get some training for us. So thank you, Paul. Thank you, Casey. Thank you, Tanisha, for spearheading this. And with that, we will start with our training. We'll turn it over to Karen, maybe she's virtual.
Good morning.
Good morning.
So I'm Karen Harrison. I'm Senior Counsel with the Fair Political Practices Commission, and I'm here to provide training on two bodies of law that involve conflicts of interest. That's the Political Reform Act and Government Code Section 1090. And I don't have control over the slide, so I'm just going to say next slide, please, when I get to that point. All right. So the purpose of the training today is a quick overview. This is where we're going to learn to identify issues, key concepts, terms that you'll want to be aware of, understanding the importance of spotting issues before any participation, how to seek advice as needed and understand that that advice needs to be sought prior to any participation, and understand that our advice is dependent upon the particular facts involved. So those are some key concepts to keep in mind as we work through this, and we'll also talk about duties under the Act, duties under Section 1090, and resources that the Fair Political Practices Commission offers in navigating these two bodies of law. Next slide, please. Just as a general overview, and as a side note, we will have an opportunity for questions at the end of the coverage of the Political Reform Act and again at the end of Section 1090. If you have a burning question, please alert me and we can stop. But this is a time for overview rather than detailed hypotheticals. We don't respond to hypotheticals in an informal setting. It's very difficult and complicated because you change the facts slightly and the answer might change. So we're going to do the overview with general questions, and we'll talk about the Political Reform Act. So this was created in 1974 in the wake of the Watergate scandal. And the Political Reform Act regulates a number of items. Campaign financing is one, but conflicts of interest is what we're focusing on today. And just note that we have a commission, we have a 5-member commission that administers the act. Next slide. So what is a conflict of interest under the Act? It's set forth in Government Code Section 87100, and it basically states that a public official shall not make, participate in making, or in any way attempt to use their official position to influence a government decision in which the official knows or has reason to know that they have a financial interest. And you'll notice that some of the terms here are in bold. These are terms that are defined under the Act, either through statute or regulation, and they're key terms to understand. The next statute, 87103, goes into a little bit more detail about when a public official has a financial interest in a decision. It's if it's reasonably foreseeable that the decision will have a material financial effect. And this is distinguishable from the effect on the general public, and that material effect is on the official, the official's immediate family, or the official's financial interest in a business entity, real property, source of income, or source of gift. Source of gift is a category of source of income. So that's the focus. In everything that we talk about under the Act, we're going to be looking at that key idea. Is there a financial interest in the decision? Is it reasonably foreseeable that the decision will have a material financial effect on the official's financial interest? Next slide. So application, what you want to think about is, what are my financial interests generally? What is the decision or decisions? Sometimes there's a bundle of decisions. What's the decision at issue? How might that decision affect my financial interest? Is it reasonably foreseeable? Will the effect be material? Does an exception apply? And then if there is a financial interest in the decision, how do I recuse? What's that process? Next slide. So I want to point out there's a relationship between conflicts of interest and the financial disclosures, the Form 700 that we all have to fill out when we're involved with the state. That is our financial disclosure that is the first introduction that many people have when they're putting on their public official hat as to what financial interests they need to be aware of that they have that could become an issue when they are making decisions as a public official. So that Form 700, while it might seem like an onerous duty to have to fill it out and fill it out every year, it's really your heads up. This is your opportunity to see what types of financial interests do you have to disclose. Those are the financial interests that are going to be something you want to think about when decisions are coming before you. And one caveat to that is we don't disclose our personal residence on the Form 700, but that is something that can come up in a conflict of interest, even though you don't disclose it on a Form 700. So think next time you're filling out your Form 700 that this is a helpful document to give you a heads up. Oh, I have an interest in this type of stock. I need to remember that if a decision comes up that might involve that company, for example. Next slide. So we talked a little bit about what financial interests are. It's a particular category of interests. So we're looking at a business entity interest. This is where the official might be a director, officer, partner, or they might hold a management position, a position as an employee, or have an investment in that business entity worth $2,000 or more. For real property, again, we're looking at that same level of standard, an interest in real property valued at $2,000 or more. These are our thresholds that are typically very easy to hit. Source of income interest. This one can be a little bit tricky. This is an interest in a source of income that totals $500 or more within a 12-month period prior to the decision. So if you're a landlord and you have a tenant, your tenant is a source of income to you. And how that decision affects your source of income, your tenant, can create a conflict of interest, even though it's not affecting the official directly. Source of gifts. An interest in a source of gifts or gifts totaling $590. That's got an asterisk because that threshold changes every 2 years. So right now it's $590 in the 12 months prior to the decision. And then personal finances. An official always has an interest in their personal finances. If a decision would affect their personal finances but doesn't hit any of these other categories, then we look at personal finances. And that's for the official and the official's immediate family. If, for example, a business entity was involved under regulation, we don't examine personal finances in that context. Next slide. Okay, so we talked about financial interest. Now we're going to talk about when a decision might be reasonably foreseeable as far as having a financial effect on the official's interest. So there's two standards. The first one is if the financial interest is explicitly involved in the decision. And this is a pretty easy concept. If they're a named party in the decision, or if they're the subject of the decision, they're going to be explicitly involved, and it will be reasonably foreseeable that the decision will have a financial effect. If neither of those two are met, then we look to see if the decision's effect is a realistic possibility. And this is more than hypothetical or theoretical, but we have this nice caveat that it doesn't have to be likely. So if it's a realistic possibility, it's reasonably foreseeable. Next slide. Now, just to dive a little bit deeper on that explicitly involved, when it's the subject of the decision, that can be a little bit trickier. Basically, if the decision involves a license, permit, or entitlement to, or a contract with the financial interest, it will be the subject of the decision. If the decision affects real property, there's another standard that we look at, and that's the materiality standard for real property. It's set out in 18702.2. And the reason why I am touching on this a little bit more deeply is that we'll have an example coming up where we're going to take a look at that regulation and how it interacts with reasonable foreseeability. Next slide. All right, then there's materiality. So we've covered financial interest, we've covered reasonably foreseeable, and now we're looking at whether or not the decision's effect will be a material financial effect. And there are regulations that set out standards for each type of interest, and they're listed here on the slide. If you were to go and look at 18702.1, for example, for business entities, it might look overwhelming. But if you have a specific business entity that is at issue in a decision, it is not so difficult to work through the regulation because you're going to start looking for how it applies to that financial interest. So don't be daunted if you were to go and look at it and try to parse through. And we are there to offer advice, formal and informal advice, if you have questions along the way. So to determine the materiality of the financial effect, you're going to apply the appropriate regulation. And in some scenarios, you might be applying 4 of those regulations, depending on how many financial interests are involved. Next slide. So this, like I said, the regulations can be a little bit overwhelming, but this is a sample of the real property materiality standard regulation 18702.2. And here I have just the first subdivision, A1 through 7. This is just a sample of this regulation. It's not the full regulation, but the first 6 items are those items that were referenced as to whether or not a decision explicitly involves the real property. And you'll see that those 6 are all decisions that would affect that parcel. So for example, if the decision would impose or modify a tax, and that applies to the official's parcel, then you're going to have reasonable foreseeability standard met, and you are also going to have the materiality standard met for that decision. Item number 7 is a little bit different. That is not one of those 1 through 6 that meets the subject of standard. But item number 7 is important to understand because it's a bright line rule. And that's a bright line rule for a decision that affects property that is 500 feet or less from the official's parcel. And this is property line to property line. The bright line rule is there will be materiality unless there's clear and convincing evidence that the decision will not have a measurable impact on the official's property. Just something to keep in mind as we go through an example later on. Next slide. So once you've run through this analysis and you've thought about, is it reasonably foreseeable? Is it material? Then you want to think about exceptions and other considerations. So there's a rule called the public generally exception, and that is where the effect might be indistinguishable. The effect on the official's financial interest might be indistinguishable from the effect on the public generally. And the way we do this is through a regulation where you're looking at a significant segment of the public, and the official has to establish this in order to meet this exception. The official has to provide facts that show that a significant segment of the public is affected and that there's no unique effect on the official. So if the public generally exception is met, the official does not have a prohibition on participating in the decision. So that's an important one to consider. The next thing to consider is segmentation. And that's where you have a decision that's actually a bundle of decisions, and the official has a financial interest in one particular decision. Sometimes the decision-making process can be structured so that that particular decision, where there's a conflict of interest, can be finally decided, and the other decisions can come down the line, and the official can then participate in those later decisions, so long as the decision that causes the financial conflict of interest is a final decision that cannot be revisited. And there's a regulation that walks through what's required in order to be able to segment a decision. And we do get advice requests where the official might say, I have a conflict of interest in this decision, or the commission itself might ask, there is a conflict of interest in this decision with one of our commissioners. Is it possible for us to structure the decision-making process in this way to allow participation? And we can take a look at that. And lastly, if a quorum can't be formed because a number of officials are disqualified, there's a regulation that allows for participation if there's a legal requirement to participate. So if you have 3 out of 5 commissioners knocked out of making a decision, there's a process. It does involve drawing straws, and so it's a scientific process that allows officials to participate. Next slide. And then lastly, the disqualification requirements or recusal. So if an official has a conflict of interest and the public generally exception and no other exception applies, the official must recuse under the requirements of another regulation, 18707. And the key elements is there needs to be a public identification of the official's specific financial interests immediately prior to consideration of the decision. The official must recuse, and if they're a Section 87200 filer, they must leave the room. And Section 87200 filers is a list of specific positions, and it includes positions that manage public investments. After the public identification, the official recuses, leaves the room, and must refrain from any participation. And remember, participation includes any sort of attempts to use their official position to influence the decision. Next slide. Okay, now before I go into the sample question, are there any quick questions right now, understanding that the sample question might resolve some issues?
Not seeing any questions in the room, Karen.
Thank you. All right, so here's a sample question. So as CTC Commission will soon consider approval of a project to construct a highway interchange. There's a particular commissioner that owns rental property located within 500 feet of the project site. So the question is, does the commissioner have a conflict of interest relating to the project? You want to take a look at what are the commissioner's financial interests? What is the particular decision or decisions at issue? If there's a bundle of decisions, you want to think about how the decisions might affect the official's financial interest. Is it reasonably foreseeable? Will the effect be material? Then you look at, does an exception apply? And then must the commissioner recuse? And what does that recusal look like? Next slide. So we identified that the commissioner has rental property within 500 feet of the project site. So pretty easy to see that there's a real property interest. It's a rental property parcel. But there's also a business interest. This official has a rental property business, even if it's just one rental. They also have a source of income interest in the rental business. So you're going to apply the source of income standard for the rental business and in any tenant of the rental property. So that's something to remember. When it looks like it might just be a simple real property financial interest, it's actually a bundle of interests, and each one has to be looked at. Next slide. So then,
I have
yes,
a follow-up question.
yes.
So you've got many different types of conflicts there. When someone is announcing their recusal before they leave the room, do they have to, how much detail do they have to give with all of these potential levels of conflict before they leave the room in a meeting?
So there has to be specificity so that the public understands what the financial interest is. So you would stand up and say, I have a real property interest in this rental property. This is a rental property business. And if the tenant is involved in the conflict, the tenant is the source of the conflict. So you want to identify the source of the conflict. And under the regulation for recusal, there's some detailed information. All right?
Thank you.
A good rule of thumb is, would a member of the public understand what the financial interest is that's causing this official to recuse? That is the level that you want to attain with enough specificity so the public understands the conflict. All right, so we've identified the financial interests that might potentially be involved, and then we're going to look and see, is the financial effect on each one of these interests reasonably foreseeable? And again, this is rental property within 500 feet of a project site. So you want to look, is the parcel a named party or the subject of the decision? And if not, is it a realistic possibility the decision will have a financial effect on the interest? So you're going to look at the rental property business, you're going to look at the real property interest, and remember we talked about how there's that standard under the real property materiality standard, A1 through 6, that you have to look at to see if real property is the subject of the decision. And there's one factor, A6, and that's where the decision involves construction or improvement to streets. And the parcel will receive new or improved services that provides a benefit or a detriment disproportionate to other properties receiving the services. That will meet the reasonable foreseeability standard and the materiality standard. Then you want to look at source of income interest, rental business. That makes you look back at the rental property business for the standard, and then the tenant of the rental property. All right, next slide. Once you've gone through the reasonable foreseeability determination, then you want to look, is the financial effect material? And again, remember that we're looking into the future. So the materiality standards apply guidelines so that you can look into the future and determine if the standard says it would be a material financial effect. There isn't absolute certainty, but because we have to look into the future and see if the standards are met. So looking at that real property materiality standard, we're just going to look at the real property here, not the business and not the tenant right now, just for purposes of this question. We're going to look at that A6, the involving construction or improvement to streets. And A7 involves property 500 feet or less from the property line. And unless there's clear and convincing evidence that the decision will not have a measurable impact on the official's property, you're going to have a materiality factor that's met. So it will be a material financial interest in all likelihood, unless there's something unusual going on. All right, next slide. Then just continuing on with the sample question, you want to look and see if the public generally exception applies. Does the decision affect a significant segment of the public? If it's a highway interchange, likely that it will be affecting a significant segment of the public, unless this is the only parcel that is located next to that interchange. And that would be your problem there, where there's a unique effect on the official's interest. So you need to find a significant segment of the public and no unique effect on the official's interest. Then you look to see if the official is legally required to participate. If no exception applies, prior to the agenda item, the commissioner recuses, states the financial interest at issue, and in all likelihood would need to leave the room.
Can you clarify again the definition of significant segment of the public?
Significant segment is not something that I dove into deep detail for this presentation. There is a regulation that governs that, and it has to do with percentage of persons, businesses, or real property that is affected by the decision, and whether or not the official has only one residential real property parcel involved. So the standard is typically 25% of the, let's say, the real property parcels, that can be commercial or that can be residential, within a jurisdiction. If the only interest is the official's residence, it's 15%. And then there's a list of factors that you look at for unique effect. It can be a little tricky to apply the public generally exception. So if you believe that you have that situation, I would recommend seeking formal advice and getting a letter from us that lays out the analysis and gives you our conclusion as to whether or not that exception would allow participation.
I guess maybe one more question for you, Karen. How often does that exception pencil out?
I don't have a percentage rate of how often it pencils out, but it is an important exception that can apply. So it's not something to cross out of hand, and it is not as difficult to come up with the numbers as you might think.
Thank you.
So
Karen.
it often makes the difference in whether or not an official can participate.
Commissioner Falcone,
A good
Did you-
example would be, oh, go ahead.
Go ahead,
Commissioner
Karen.
Falcone, did you have a question?
Yes, thank you, Douglas, and thank you, Karen. So if an official owns a piece of real property and there is a, let's say, an improvement that abuts that property, but it's larger, it's part of a larger program of projects that receive funding that go before the commission. Is that considered public generally exception, or is there materiality in that?
So the best answer is I don't know from those facts. So I would need more facts. And if that's a scenario that you would like me to take a look at, I would recommend that you send an email to me with facts as specific as you can get. And if this is something that pertains to you, if you would like formal advice, we can do that. I can also point you to guides that we have that would help you to sort through what facts are pertinent to that, because I don't have a full enough picture to answer the question.
Okay.
Next
Thank
slide. Okay, so I thought it was good time to go to this. We have a wonderful website, and we have many resources available on our website. We have a section that's called Learn, and you click on Learn, and you can go to the conflict of interest rules. And there is a long, detailed walkthrough of conflict of interest, and you can scroll to the part that pertains to the decision you're concerned about or the financial interests you're concerned about. You can go to our advice page, and you can request informal advice, and that can be by phone, by email, or it can be by formal written letter. For formal written advice, we are allowed 21 days to provide a response. It's 21 days from the date that we get a full set of facts. Often we'll get a question that might not present all of the facts that we need to provide a response. So when you feel like a decision is coming up that may implicate some financial interest, it's a good idea to start thinking way ahead of the process as much as you can and send in a request for advice. And it can be sent in to our email address, and it will be assigned to an attorney, and that attorney will get back to you and ask you more questions if needed. Be as specific as you can on the facts. We are not a fact finder. We don't go out and investigate. We can Google just like anybody else, but we don't go out and investigate. So we rely on the facts that are provided, and our advice is based on those facts. So our advice provides a certain level of immunity for any official that requests and receives formal advice. But that immunity is only as good as the advice letter, and the advice letter is only as good as the facts that it's based on. So it's a good idea to give as complete a set of facts as you can. And the specificity of the decisions is really important, because if we don't have a specific decision to analyze, it's very difficult. Basically, we just have to return chapter and verse of the statutes and regulations that might be implicated, and we really can't come to any kind of conclusion without knowing the nuts and bolts of the decision. Next slide. This is more information about the resources that are available that you can access yourself on our website. Our advice letters, our past advice letters, are not precedent. They're not like a court case or an attorney general's opinion. They are specific to the official that requested the advice, but they can give you a sense of a general picture of what the advice letter is looking at, what the concerns are, what the conclusion is. But do be aware, the law has changed from time to time. The 500-foot bright line rule under the materiality standard has been in our regulation for some time, but it was worded differently and it was in a different location. And so you'll see a different reference in letters that were prior to, I believe it was 2017 when that changed. So do be aware of that when you're looking at old letters. Next slide. All right, are there any questions? And specifically, are there any questions about the formal advice process?
No, Karen.
All right, hearing none. So now we're going to go to the next body of law, and this is Government Code Section 1090. An important thing to remember is that often when we're looking at decisions, we are going to do a Political Reform Act analysis, and if that decision involves a contract, and a contract here, we are loosely defining a contract under Government Code Section 1090. It's any agreement that might qualify as a contract. So think development agreement, grants, and of course a contract agreement. Those are all going to require a Government Code Section 1090 analysis. It's a separate body of law, and it requires a separate analysis. So we're looking at financial interests, but financial interest is defined separately under Government Code Section 1090. So it provides essentially that public officials shall not be financially interested in any contract made by them in their official capacity or by any body or board of which they are members. Next slide. So you got your basic rule. If a public official has a financial interest in a public contract, Section 1090 is going to prohibit the official from making or participating in making the contract, and it's going to prohibit the official's agency, including a board or commission, from entering into the contract.
Are
I'm sorry.
are allocations and awards that we make considered contracts?
I don't know. I don't have enough facts to answer that question. But if it's a grant award, grants typically fall under the category of a contract.
Yeah,
Yes, but we'd have to double check.
can you find out for us? Just
Usually,
curious.
yes, absolutely. If you send in some information with some detailed background on what's going on, we can take a look at that. And as a general rule, a contract is where you have an offer, an acceptance, and consideration, and that's your contract. So it is very easy to hit that standard.
And it's with whom?
So Government Code Section 1090 codified a common law prohibition. So it has been something that has been percolating in the legal system for quite some time. And the courts have weighed in on Section 1090 as well as cases in the past under the common law. And it's the courts that really provide the guidance on the interpretation for this law. And let's go into the next page.
Karen, can we pause for just 1 second to get a
Yes.
clarifying question?
That's basically all we do.
So at the end of our allocation process, there is a contract that Caltrans enters into either with a local agency, with a grant recipient, which can be a university in some cases, or some other entity. When we talk about the contract and the potential conflict under 1090 for the commissioners at the table, are we talking about a contract that is entered into with the commissioners or an agency that they are affiliated with? Or are we simply talking about a contract that they may weigh in on?
So when you say weigh in on, that sounds to me like participate in making the decision. So if there's participation in the making of the contract, and the courts have interpreted this in a very broad fashion, that's any type of negotiation, participation in early meetings where they might have talked about the contract. You're going to be looking at participation as a factor that'll be met. The courts, I'm going to get a little bit ahead of my presentation, but it's good to understand that the court broadly interprets all of the terms for Section 1090. So public official, in the language of the law, it's officer, and it's broadly interpreted. So that can mean a public official as we typically think of a public official, an employee, a public employee, or an independent contractor under certain circumstances where they're entrusted with transacting on behalf of the government agency. So all of these terms are very broadly applied. There are some exceptions, and the court has been very clear that they are narrowly applied. So let's go to the next slide, and we can come back to that question because if you still have questions about that. But I want to talk a little bit more about 1090 just as background. A contract in violation of 1090 is void. It's not voidable, it's void. And this is regardless of whether or not it's a good contract. If it's a fair and equitable contract, it does not matter. It's void. It's subject to disgorgement. That means that the profits can be clawed back, and there is a prohibition that applies to the entire governing body. So when a member of a governing body, such as your commission, has a financial interest, recusal does not cure the defect. The entire board will be prohibited from entering into the contract, unless an exception applies. So that's the silver lining. Next slide. So there's penalties with 1090. There's civil penalties, there's administrative penalties, and there's criminal penalties. It's important to take Section 1090 very seriously. Next slide. So this is my broad interpretation slide. Basically, it's broadly interpreted by the courts to ensure the official's absolute loyalty and undivided allegiance. This is language from a court case. And the appearance of impropriety is sufficient to violate Section 1090. Again, that talks about the fairness of the contract. Officials have claimed, but this was a good contract. This was not, undue advantage for one side or the other, and the court has not cared. Because that is not how 1090 is written. That's not the language of the statute. So it's immaterial. Next slide. So the application, what you want to look at is there a contract decision? And again, contract is going to be broadly interpreted. Am I an officer under section 1090? You all are serving on a commission, and so you would all meet that definition. Where officer definitions get tricky is when the commission is contracting with an independent contractor. What type of financial interest do I have related to the decision? And again, this is sort of like the analysis in the Act, but very broad interpretation of financial interest. We'll talk about that a little bit more. Does an exception apply? Very important in a section 1090 situation. Does the rule of necessity apply? We'll talk about that. And then what are the recusal requirements? They're slightly different from under the Act. So some key concepts: the importance of spotting issues before participation. We can only provide written formal advice on 1090, and we can only provide formal advice when there's been no participation. Otherwise, we call it prior conduct, and we're not allowed to provide advice. I think I've emphasized this enough, but it's a key concept. So very limited application of the exceptions, very broad application of all other terms. Any questions on this slide? Okay, let's go on to the next one. So officer employee, it applies virtually to all state and local officers, employees, members of governing bodies, whether elected or appointed. Includes some independent contractors, as we discussed, when they have that duty, when they're entrusted with acting on behalf of the government agency, then they're going to fall under section 1090. And there's a California Supreme Court case that set out that standard in 2017, made it much clearer for all of us. Next slide. Financial interest, broadly interpreted to be anything that would tie a public official's fortunes to the existence of a public contract. This is if it would profit the official in any way, but you have to remember, this can be a financial interest that is direct, indirect, it can be losses, and the possibility of losses or the possibility of gains. So a financial interest is not always good finances. It can negatively affect your finances. And again, we're looking at possibilities. So this is a very broad interpretation. Next slide. The statutory exceptions. The legislature has drafted very specific statutory exceptions. These are known as remote interests and non-interests. Remote interests apply to a commission such as yourself, where you have a board making decisions. And it can apply if the official's financial interest meets the specific definition of a particular remote interest. And I believe there are 17 of them under that statute. And it has to meet the language of the specific remote exception. If it's close, but it doesn't quite meet it, the court has interpreted that as meaning that it absolutely does not meet it. So close is no cigar in this one. If a remote interest applies, the contract can be made by the board. If the officer discloses the remote interest, the interest must be noted in the official record, and the officer must completely abstain from participating in making the contract. So the Act would require the officer to leave the room as well. But under section 1090, it doesn't have that requirement. So you have to be careful when we do the two analyses. We always try to point that out in a letter that if you're out under the Act and under 1090, you must leave the room if that section applies to you. Under a non-interest exception, these are financial interests that the legislature has deemed so minimal that the official is not deemed to have a financial interest in the contract. They have a non-interest, and that official is not prohibited from participating in making that contract. Now, there are specific provisions in that section that may make a non-interest apply, and part of that non-interest application may require the official to identify their non-interest. So it's tricky. It's something to be very careful of the details and the requirements under a specific exception that may apply. Are there any questions? So just a little example for remote interest would be if you were, say, a landlord or a tenant of the party that is involved in a contracting decision that falls under a particular category of a remote interest. So in that case, the official would not be allowed to participate in the decision. They would have to disclose it. They would have to abstain. All right, next slide. There is a limited rule of necessity. And again, we're guided by case law and attorney general opinions. And there are some excellent attorney general opinions that go through the details of the rule of necessity as well as the court cases. It can apply in two narrow situations. The first one is the procurement of essential supplies or services. There's a great case that involves procuring ambulance services. So that would be an essential supply or service when no other option is available. And that doesn't mean that there's other options available, but they're inconvenient. It really needs to be no other option is available. And the second is when it's to carry out the essential duties of the office, and that governing body or that particular official is the only one authorized to act. So it's very limited rule of necessity. And again, you would want to seek formal advice to see if that applies in the particular situation. Next slide. So basically 6 steps that you're going to look at. We've covered these, I think, in pretty good detail. Is the person subject to 1090? Does the decision involve a public contract? Is the official making or participating in making the contract? Again, broadly interpreted, any type of negotiation involvement would meet that requirement. Does the official have a financial interest? Broadly applied, any interest, financial gain, possibility of loss related to the contract. Does a statutory exception apply? Does the rule of necessity apply? So if you're taking a look at these 6 steps, we recommend you seek advice through your agency counsel, and your agency counsel can come to us or you can come to us directly. If we do get a request from an independent contractor, and let's say they are wanting to bid on a contract with the commission, and they are told, no, you cannot bid on this contract because of a Section 1090 conflict. We think that you are an officer under Section 1090, and so you cannot bid on this secondary contract or this future contract. If the independent contractor seeks advice from us, we will require the agency to also participate in that request in order for us to issue formal advice. And that way we don't get into a situation where the independent contractor might be giving us facts that the agency doesn't agree with. And so we go back to the agency and we request that the agency also partner on that letter and sign off on the facts or supplement the facts and ensure that we have one statement of facts from both parties before we provide that type of advice. Next slide. So here's a brief example. So we have a member of the County Board of Supervisors. They're looking at a contract with a fire alarm installation company, and one of the supervisors owns the fire alarm installation company. So here you would do an analysis under the Act as well as Section 1090. Next slide. Looking at the 6-step analysis, the supervisor is definitely subject to 1090. The decision involves the fire alarm contract. Given the board's role in approving the contract, the supervisor is presumed to be participating even if they recuse. So there's participation. The supervisor has a financial interest as the owner of the company. There's no non-interest or remote interest indicated, and there's no indication that there's a necessity. But again, the facts would be very important in this if this is the only fire alarm company that could possibly provide this service. But I think I heard a question.
Nope, not seeing
Okay.
any questions in the room.
All right. So 1090 would prohibit the supervisor's participation, and it would prohibit the county from entering into the contract. So next slide. So again, we have resources available on our website regarding 1090 and how you can request advice, what are the requirements to request advice. We cannot provide informal advice on a 1090 question. We can point you to general guidance, but we cannot give informal advice. We are required, when we receive a 1090 request, to also provide the request to the Attorney General's office and to the county district attorney that's involved. And we have to wait 30 days for them to have an opportunity to respond. Our jurisdiction in responding to Section 1090 requests is limited. So we're limited to providing formal advice because of that requirement of notification and weigh-in by the AG's office and the DA's office. We don't always get a response from either entity. On rare occasion, we will get a response from a district attorney, even rarer to get a response from an attorney general, but they are aware of the request and can respond if they feel it's important or necessary.
So I do have a question.
Yes.
Sorry. So when you were applying the 1096 step analysis, and it seemed like, oh, that's a no-brainer. Supervisor has owns a company that they're gonna vote on. He can't participate, but the end was that the county, they can't vote on it at all. That can't even come before the county because one of their own owns an entity that they might vote on. Was that what you said?
That is the law under Section 1090, is that a body or a board of which the official is a member is also knocked out from making that contract. If one of their members has a financial interest, it knocks out the board.
So we would have to know that one of our members has a financial interest in whatever way of any of the contracts that we deal with. And then we that couldn't come before us.
That's correct.
Fall into necessity if we're the only body that can vote on it. Right.
Rule of necessity may apply,
Okay.
We all-
but don't jump to rule of necessity. It would be a bad assumption to think that it would apply. In those situations, you would want to get advice letters from us. And advice letters are very helpful. If you have one or two contracts that you request advice on, and a commissioner may have a potential financial interest, the advice letter should give you some really good parameters to apply that letter to other situations. Sometimes it takes a couple of letters to fill out those what if types of situations, but for Section 1090, it's so specific. We need to have the contract in order to do the analysis. It has to be formal. I would recommend that you get some advice on a few contracts, and there's no limit to how much advice you can request. The only thing that we need is specific facts in order to provide it.
And then we'd have to go on record on what would be an exception based on the letters, correct?
Well, yes, if a remote interest applies, then you would follow the rules of participation when there's a remote interest, and that can also be required under particular non-interests.
Okay.
So one thing I will offer to all of you all, that we are doing as a staff, well, the first thing we're doing is we're hiring a lawyer, an in-house counsel. So we're moving forward with that, which will hopefully help. I will recognize that we have one position for a lawyer. One lawyer will not know all of the laws that apply to us. So we will need the support of the FPPC, which means we will have to seek those advice letters as we're moving through this process, as each of you have new conflicts, remove different conflicts, whatever may be the case over time. But that is one thing. It does sound, and from looking at your faces, you all clearly have more questions, specific questions that Karen clearly will not be able to answer without all of the details before her. Some of those, just to be clear on what Karen has said, some of those can come in informal advice. Not on 1090. 1090 is going to be specifically formal opinions. And so we'll need to provide as much information as we can to Karen so that she can give us a formal opinion for your individual circumstances, because they will be individual to each of you, but each of you circumstances in 1090 may impact all of you. And so we'll have to understand what those answers mean across the commission and how we do our business. There's this larger question of what is the definition of a contract and the making of a contract, right? Because it's not just signing the contract, it's the influence throughout the process. And so we'll have to follow up on some of those questions as we move forward. Did I get it right, Karen? Did I
Yes, yes, and I would just comment that we do have advice letters on 1090 that are available to review, and we can refer you to an advice letter if we think that it would be helpful, so you can see what advice we might have issued in the past in terms of defining something as a contract. But I would say that if you have a particular decision in mind, and that is your question, is would this meet the definition of a contract, let us know, and we'll see how we can best answer your question. And just one caveat, just peculiar to us, what we write are advice letters. We do commission opinions, but that is a separate process. And so if you're looking on our website and you look at commission opinions, those are a particular thing. What you are really wanting to look for are advice letters.
Thank you, Karen. One other thing that I'll offer, we do have a repository of prior general counsel information from our retired and we had a lawyer. So we can go back through that list of letters that we've gotten to see if we already have some information that we just.
And one other caveat is that we can only provide advice on future conduct. So if it touches on past conduct, we can't advise on it.
Preventative measures, we got it.
We discuss which commissioner would have the best bug name.
Yeah.
So I believe that's the end of my slides. I don't think there's any after that. Maybe it just says questions. There we go. Oh, just limitation on our authority. We covered that. And next slide after that. More information. So quick guide to section 1090, quick overview of our providing advice. Those can be very helpful resources to start to sort through what's going to be an issue, what's going to be an issue right away, and what maybe isn't something that you need to be worried about. And let's see if there's another slide. There we go, just questions. So are there any questions regarding 1090 or regarding the Act?
Karen, I'm certain there are, and we will be following up with you.
That's absolutely fine. This is our mandate. This is what we do every day, is provide advice to folks that have a duty under either body of law. And so, please use our service. We're happy to play this role, happy to help you sort through it.
I'm sure Douglas can send us the right direction, but when we're looking at back to the Act and the forms that we fill out, sometimes it's squishy on when, like for the dinners and the lunches and those things, if it's a event that we're going to and somebody's already paid for all of it, does that count? If it's a reception, right? Do we have to say, okay, that reception was worth $50 and we put that? If we're going to a dinner that's some other entity has already paid for, sometimes it seems like we have to account for that and sometimes we don't.
You do, on your Form 700, you do need to account for that, unless you donate or you repay the funds.
So I can send you a fact sheet that covers gifts and gifts of travel, meals, entertainment, events. The rules are very specific, and you can just work through the fact sheet and see what applies to your particular situation. There are past advice letters that have been written to your commission regarding specific events. I'd caution that many of them are older letters, and so you want to be sure that they're current, but I think they would give you some guidance. But I'll send the fact sheet to Casey, and she can share that with all of you. Like I said, our website is just a very good website with a lot of information, and go to learn, and then you can click on anything you have questions on when you're filling out your Form 700. There are plenty of resources to help you fill out your Form 700. And if you still need help, you can always call the phone number or send in your Form 700 question through an email, and our Form 700 people will help walk you through any particular situation so you know what to report. And it's important to know when is something a gift, because you do have that gift limit. And then if you are reaching that standard, you're going to have a source of gift interest in a potential decision. But really, I think that for the commission, from what I'm hearing, the big issues are going to be on those contract issues.
Thank you.
All right, anything else?
I think we're good.
Hearing none, thank you so much for inviting me to join your meeting. And I hope this training was helpful, and I hope it's the beginning of sorting through some things so you have a better understanding of how you interact with the Act and Section 1090.
Very helpful. Thank you. Thank you. Okay, now we have to breathe. Get out our magnifying glasses.
Yeah.
Do you want to take 5 minutes before the next one on budget? Yeah, 5 minutes. Okay, thank you.
Wait, seriously, who'd make the best bump me?
Yeah.
Do we want to go to?
I didn't have the right.
Okay,
Okay, thank you. Oh, you're up.
okay, so for this next part of today's training, I'm gonna go over the commission's statutory responsibilities. So next slide. Okay, these are the topics that I'll be covering. First, I'll go through the general statutes and then into the other areas that I'll go through. Next slide. Okay, so the general statutes for the commission are in Government Code 14500. And this was added back in 1978 by Assembly Bill 402. When the commission was established, it replaced four independent consultation bodies that were consolidated into the CTC. In this statute, the commission is placed under the Transportation Agency, as you know. That was not always the case, however, that occurred as part of reorganization back in 2013. A statewide reorganization of boards and commissions. Prior to that time, the commission was freestanding body. However, when the commission was moved under CalSTA, the statute was also amended to say that the commission shall retain independent authority to perform those duties and functions prescribed to it under any other provision of the code. This section of statute also has the requirements for appointments to the commission. And I won't go through, I think you're all obviously familiar with membership on the commission. But I will just point out that the statute does, in making appointments, require the governor to take into consideration geographic balance, as well as having a diverse membership on the commission. And the statute also does say that commissioners are to represent the state at large, so not particular areas of the state. This part of the statute also has a couple of provisions regarding elections for the commission. So it requires the election of a chair and a vice chair, as you know. And in statute, the term for the chair is 1 year, and a member cannot serve as chair for more than 2 consecutive terms. The statute also requires the commission to have 4 committees. The members of these committees are to be appointed by the chair. And the committees are aeronautics, streets and highways, mass transportation, and planning. The statute also says that the commission cannot form a committee to consider budget and fiscal matters. And the chair can only serve on one of the committees as an ex officio. And so you may be wondering about these committees.
Yeah, we are. Oh, does the language say must? Does it say shall?
It's a shall for the.
Shall.
So
Does not specify how often to.
it doesn't specify, it's very brief, yes. It's
35 years, good.
Doesn't really say what they're supposed to do, how often they're supposed to meet, or anything of that nature. My understanding, and I've only run the commission a couple of years, and the committees have not met in the time that I've been here. I think it's been quite a long time since the committees have actually met. I think for a variety of reasons. I think one, it just wasn't maybe clear, given the structure of our meetings, what these committees would necessarily be doing. And secondly, I think maybe way back when the committees met and maybe reached a decision, I think the way the commission has functioned historically, all of the commissioners have been very involved in all matters. So it was not maybe necessarily the most efficient way for the commission to conduct its business.
So in this section though, does it state what those committees are designed for? What their purpose is?
Okay, so I can read it to you.
Read me one.
Yeah. The Committee on Aeronautics, which shall consider issues related to aeronautics. That's all it's saying.
What?
There we go. No, I mean, the only one that has a little more specificity is the Committee on Planning. The other three are just like the one that I read. The Committee on Planning, a little more specific, I would say, because it does talk about recommendations related to how the commission is allocating federal and state funds available for planning and research.
For what?
Planning and research.
Commissioner Grigsby, did you have a question?
Yeah, so four committees, aeronautics, mass transit, planning, what was the last one?
Streets and highways.
Streets and highways. Thanks.
I know Vice Chair Gardino said a long time ago, he was appointed to the aeronautics, but they never actually met.
Yes, yeah, so I think for a long time. Was appointing members, the committees were not meeting. I think in more recent years, we haven't even done the appointment.
For any of them, right?
Right.
It was one of the things I think we lost during COVID. Prior to COVID, I recall them appointing, and the minutes of our meetings reflect that. I think it was 2020, maybe 2019 was the last time we appointed the committee. I want to say Paul Van Kenenberg may have done it March 2020.
That wouldn't be him, that
No.
would have been Cory,
Yeah.
Yeah.
and you didn't do it, right?
No, I think he was still our chair March.
In
Yes,
March,
May.
Yes, she became the chair in August.
because they didn't read.
Yeah.
But, I don't, did he report those?
We did, there was an appointment, it was probably on consent. Because.
No, it's part of the commission reports, if I recall. I can pull up the minutes.
Very good. That's fine.
And he appointed someone to each of those, all four?
2 or 3 commissioners, yes.
Okay.
Oh, okay.
Yes, no, the aeronautics, we don't have transit.
Oh.
Sweet.
You're happy about
You're
that?
on planning.
I'm on planning?
Yes.
Where did that come on?
And
On our website.
committees.
Fran Inman is still listed as being on planning, so.
So, friends on planning, that's good.
Bob Alvarado might still be listed on one of those.
So they're all updated at that.
Are they?
But
I
Commissioner
think
Powell,
that's
come on, when
I
did you come
think
on?
that's an error.
Active
September
transportation.
2020.
Yeah.
So you put up the road chart there.
That's
It's
what
there.
happens.
It's good.
Yes,
It's right now.
so that one I know.
On the website?
Yeah. So the websites are wrong.
We can clean up the website and we can go back to the minutes to find the last time we appointed commissioners.
Or you can just make new appointments.
Oh, I'm definitely gonna make your appointment, now that you've spoken up.
Is it?
Commissioners have the right to.
I'm already sending an email.
So you're not even- Is that another former commissioner?
Yeah. Commissioner Falcone, how long have you been on the commission?
Yeah, Christie
almost
Ho,
2 years.
right.
It's 2 years, so it's 2 years, that's.
Oh, okay, so when you click on that link, it goes to.
Senator Kehoe's still listed.
Yeah.
Yes.
She's on the commission on the committee with you.
Yes.
I can confirm March 2020 committees were appointed.
Good thing our website is quick to update and easily
Yeah.
change.
Hey, go there, delete.
Yeah, it looks like the aeronautics one for commissioner.
You gotta announce them tomorrow.
Good. It's not on the agenda, but.
I always.
Sure, it's like the commission updates. This is an upgrade.
Oh.
Okay, so. Moving on.
Put me in jail.
I want to figure out who.
Well, and I will also say, at least in my time at the commission, no one has ever inquired about the committees. We've never had any questions about them or why they're meeting or not meeting. Okay, so there's also in statute 2 advisory committees that the commission has. And they may not be the 2 that you think of. So one is a technical advisory committee on aeronautics. So that is different from the committee on aeronautics that I just mentioned. This is a technical advisory committee.
Okay.
And the second one that you do know about is the road charge technical advisory committee. So the aeronautics tech has not been formed or met in recent years. Road charge tag, though, as Commissioner Liu knows, does meet regularly all the time. And then just to the point of clarification, I think as you all know, the Equity Advisory Committee is not in statute. That is something that we form.
But it does say in statute that we can make additional committees.
Yeah, we can make committees.
You found that in there?
I don't,
Does that?
I move that we make a committee on committees.
Well,
yeah, because, okay, are you talking about the committees or?
So
so
not the formal committees where EAC falls a technical advice.
The
there's
formal
something-
committees, it says we need at least 4, and then it lists the 4, so the at least would suggest.
You could have more than
that you
four.
could have.
Are you going committee crazy on us right now?
Well, if we have an equity advisory committee, where does it say we can do that?
Oh.
Where does it say in our statute that we're allowed to add a committee?
An advisory committee, I don't know that there's express authorization anywhere, but there's no
Nothing
prohibition.
that says
either.
we can't.
Yeah,
Is that formally the same kind of committee though? Because none of us are on.
It is not formally the same kind of committee.
Right. It's more like a council.
I thought that there was under CAPTI that there were gonna be these like tolling committees and a lot of other committees that CTC was supposed to be seated on as well as.
those are more like work.
Cat
groups.
trend.
Groups, not committee.
Yeah.
Okay,
I think one of the challenges we have across all of our state agencies is that each agency uses a different term for the same thing, right? It could be a work group, it could be a committee, it can be, you name the synonym, and they have the same effect. One of the differences, are statutory committees, because commissioners sit on them, there is compensation, you know, that full $100 you're rich. For our working.
We don't actually
officers
call
of
it
our-
compensation.
No, our other committees, as you all know, we had to get special authority for the equity advisory committee to compensate them.
No limit on theirs. There's one day, but a month.
well, I am actually excited that I appointed Joe to the road user charge because he's been a fantastic chair, so congratulations.
Nobody.
We are clearly close to lunch.
No, I got appointed and then the governor announces that every car is gonna be an EV and I'm like, wait. Yeah.
And I would also say, I think as you know, we did, with the budget this year, so just recently enacted, effective July 10th. We have the authorization to compensate members of advisory committees. And that statute does say advisory committee includes, but is not limited to the road charge tag and the aeronautics. So that clearly applies to the equity advisory committee. Okay, compensation, I think, as you know, is
So
in
would that be-
statute too.
That would be in addition, let's just say, for using Commissioner Review as an example. If we limited to 8 under the commission. Would he be able to
I
add
don't think I'm that lucky.
to that?
No,
No,
no.
it's still only.
Let's not try.
Oh,
that. You are really trying to get me thrown in jail. aren't you?
right now, it's like the way the statute's worded
By
is
another
each
day.
member of an advisory committee who is not a commission member,
Oh, okay,
he cannot get.
okay. Just checking. I'm trying.
Thanks.
Cause I was gonna put everybody on a commission, on a committee. Yeah. You could get on. Oh.
Okay, so I think as you know, the compensation is in statute to be the $100. This section of the statute also says that the commission shall appoint an executive director to administer the affairs of the commission, and we just went through that process
We
recently.
did that, yeah. Check
Um,
that box.
And it also says the commission may employ its own legal staff or contract with other state agencies for legal services or both. And as you heard, we are in the process, we're going to be hiring our own legal counsel. And we can be sued or sued as a state body.
You could say that again, we can be sued.
We can be sued or
And have to.
do other.
And does that attach to individual members or just the body? So
it refers to the commission.
Yeah, but you can be named as an
So-
individual too.
It depends on the issue.
Lucky you.
There's,
Well, it depends on the attorneys and who are suing you. They can,
Anybody can sue anybody.
yeah, they can sue you in your individual capacity or as a commission. Yeah. And then when you apply for a loan, you have to like explain it to the bank. Yeah, I'm sued, but it's because, don't worry, I have protection.
oh, back to you.
So I'll just round it out by saying this part of the statute also has the requirement on the joint meetings. We have to hold at least 2 of those per year. There's nothing in statute about how many regular business meetings we have to hold or anything like that, just for the joint meetings. Okay, next
And the
slide.
joint meetings are in statute, so it's the,
Yes,
it's not the tri-state ones. That's not in
Nope.
here.
the tri-state are not in statute.
Okay. Those are just because we like them.
Yes.
Okay, so here, I'll quickly go over commission programs. So I added the statutory references for you for the 9 largest, which are the ones that we mostly discuss at our meetings. Are there. Just to make a couple of points, for each of the programs, the statute really is setting a lot of parameters. Well, I guess to start, the commission on its own did not, or has not created its own program. Programs, they need a funding source, and so that comes from statute. And statute determines what funds are available for the program. The commission on its own cannot redirect funds between programs. So we can't move state funding, between the active transportation program and the shop, say. Only statute can do that. And statute sets forth the purpose of the program. Generally, it'll also have, it varies for each program. Some, the statute's a lot more specific than others, but it'll have things like eligibility requirements and things like that. And then it'll usually say the commission can establish guidelines for the program. And that's where we will specify sort of the more specific evaluation criteria that we're using. So for example, for the active transportation program, one of the statutory purposes is, enhanced safety, but we sort of, in our guidelines, develop how we're going to evaluate that through the application. In some cases, we can determine the length of the program cycles. So for the STIP and the SHOP, it's in statute. Those are 2-year programs that we're doing every 2 years. But for others, like the active transportation program, the SB1 programs, we can decide, do we want to do it every 2 years, 3 years, 4 years? And in some cases, we change that over time based on various factors.
So which are the ones that are in statute that we don't have?
The STIP and the SHOP are every 2 years, I think.
But ATP, we have to adopt a program one time, so 2 years.
Oh, yeah, yes, ATP, you're right. Yeah, the SB1 programs, the discretion. And so as you know, in our guidelines, we also are setting policies related to efficient use of expenditures, time and use of funds and things of that nature. And I think as you're all aware, the way we kind of fund projects, I like to think of it as sort of a 2-step process. So we are adopting new programs of projects. That's when we're saying, we're committing funds to these projects, and that's a new commitment of funds, and that occurs under the policy matters on the commission agenda. But that can, we can be setting those funds aside, as we talked about 2, 3, 4 years into the future, depending on the program cycle. And then when in the year that the project's programmed is when the agency will come forward for the allocation, which is a long list of items on our agenda. And that's what authorizes the agency to start spending money in order to be reimbursed. Or Caltrans just authorizes them to start spending. Let's see. Okay, and also, as part of this, I think as you're aware, we're also a responsible agency under CEQA. So projects have to have cleared CEQA in order to receive an allocation. And that's where on our agenda we'll approve the project for future consideration of funding. We don't conduct the CEQA analysis, that's done by the lead agency, which would be either Caltrans or their local agency. We're just the responsible agency. Next slide. Here, this is just for reference and we can share, I think we sent up these slides, but this is just a summary of the 9 largest funding programs. I won't go through them. I think you're familiar with them all, but just really quick points. You'll see the 2 largest funding programs are the SHOP, which is our state highways, and then the local streets and roads program. Those are by far the largest funding programs. Our role can vary with respect to the programs. So the one I think that stands out the most is the Transit and Intercity Rail Capital Program, where I think CalSTA is the one that is actually programming the projects and choosing the projects, and we are just later allocating the funds. That one's somewhat unique. And I'd also highlight most of the funding is not for competitive programs. So the largest programs that we have tend to be more formulaic based, or it's for the SHOP, which is just for Caltrans. And you can see towards the bottom, the relatively smaller programs are the ones that are competitive in regions.
So can you go back just real quickly? So for the Transit and Intercity Rail Capital Program, can you talk about how that, like how the person applies and then where it goes from there, before it ever gets to us? How does that work?
So
Different than the others?
yeah, so CalSTA will do, similar to us, CalSTA will have workshops to develop their guidelines, which will kind of set forth, similar to our programs, how to apply, what the evaluation criteria are. And then the applicants will apply to CalSTA. CalSTA does, it's very similar to our programs, they'll do cycles every 2 or 3 years, I think. And then CalSTA will announce their awards. And then when the agency is, the year that they have the programs ready to start spending the funds, they'll come to us for the allocation authorization.
And are we involved anywhere along the line before it gets to allocation?
We haven't been involved in the last cycle. Prior to that, we were not involved.
Can you repeat that? So we were involved in the last one, but not
In
part.
the last cycle, we were involved, the augmentation portion of the last cycle. Prior to that, we were not involved in the decision-making process or the evaluations.
And then it just comes to us and says, okay, now allocate. Now vote to allocate for decisions that they made along the way.
Yes.
And so before it comes to us, then what do you all do with that? Those-
Traditionally, if I set the augmentation aside.
Yeah.
Nothing. We
you
have an
send it over
allocation
to us
policy.
and say, go.
Yes.
Does CalSTA update their guidelines
Yes.
at every cycle, but we're not consulted on the guidelines?
We have that traditional now. We are working to be better partners.
That's-
Yeah.
I heard them say they are working. Yeah. I guess my confusion is. Then why did we vote on it if?
You got the first to ask that question.
Question that we have wrestled with well before myself or Paul were on the commission. The challenge of having a program of projects that is developed, then comes to the commission for allocation, reconciling some of the technical pieces of how those processes fit. When I started my tenure at the commission, about 3 years ago, I know the team was working on an allocation policy to try to smooth that process. You often hear our team talk about some of the challenges in the allocation process that they've been working through. We are still working through those challenges. I think we'll continue to work through those challenges because it is a statutorily driven item. I'm not sure why this statute was written that way. I can imagine some level of oversight in terms of Caltrans on the back end. Following the process, because traditionally a cabinet level agency is not running a program of projects. If you look at Cal EPA, they're not running a program like Turk.
So
That's much knowledge as I had.
I don't want to derail us, but reminds me of a
Can I ask
question.
one question before
Sure.
you ask your question? So we're working on the assumption that we have a hard stop at noon. We can go over noon if you all can go over noon. And have a piece of.
12:01 right now.
We've already done it. We've already done it.
Awesome. Sorry.
So I lost my train of thought, so. I have to get back to you.
I'm sorry.
Yeah, you didn't want to derail something and now you lost the train of thought. So, yeah, there's a theme.
Sure, yeah. Allocation policy, the processes meeting.
Why we only allocate and we don't actually run the program or.
Yeah, it'll come to me. It was something along those lines, but yeah.
So when we vote on it, we don't really have the background information from staff that these are appropriate, that they're.
So Caltrans does review it in the same way, I'll say a similar way. To the allocations that come from other programs like the Shaw or from even our SB1 programs, where they're looking to make sure that they're not violating the law, that the scope is consistent with the program that has been or the product that has been programmed by CalSTA. We do get reports on the agenda about what these projects are. I will acknowledge that these projects do change over time. And so tracking how they change over time, how they change within our allocation process has been a little bit of a challenge for our team to track and make sure that we're from beginning to end aligning those pieces. And that's where you see our team can asking more questions about the program and how we align them to make sure that we're meeting all the statutory and regulatory requirements.
I remember now.
Awesome.
Thank you. Your
I'm gonna
question.
keep talking until you.
Your question jogged me. So given that usually cabinet level agencies don't do grant programs, what you just said, right? Are they any good at doing this, given that? Just from your point of view? Yeah.
Stop the recording.
I think they are doing a good job administering the program. There are challenges with any large program where you're talking about billions of dollars of capital projects. Collaboration is always a place where all of our agencies, including ours, can improve. That's about what I got right now.
And they understand that we're here to help if they need it, right?
So. Like other funding programs. Does this particular program go through, public process workshops?
The guidelines development process does go through a public workshop development process. CalSTA's decision-making process ends with an announcement of the projects. So in that regard, it is a public process. It is different because they are not a commission or a board. Yes.
And they don't have an open meeting where they have those discussions. They also have the ability to do that.
That's correct.
Okay.
There's some really cool projects.
I'm gonna say something.
There's that program has some really cool projects.
Okay, so, just one last point on the programs that I was gonna make. I sort of was alluding to it before, but to hone in a little bit, so. If you look, I mentioned earlier, the largest programs that fall under us are for state highways, local streets and roads. We just talked about TRCP, which is the next largest one. It's really kind of more a CalSTA program in terms of awarding the money. None of the programs that we have, I know transit operations funding is obviously a really critical issue right now. But with the programs that we have, we're not able to fund transit operations. Some of them we can fund transit infrastructure, but not operations. And that has to do primarily with restrictions on the use of gas tax monies in the state constitution. As well as sort of the statutory framework of the programs. So obviously the State Highway Operation and Protection Program is for the state highway system, which doesn't generally have transit on it. Last questions on programs, or else I'm going to move on.
We'll talk to you later.
Okay. Next slide. Okay, so we'll go through some of the planning responsibilities of the commission. So here our role does vary a bit in statute depending on what the plan is. In some cases, we're adopting guidelines for Caltrans. In other cases, we're approving plans. In other cases, we don't have a statutory role, but we can still choose to provide comments. I think myself and our planning staff are not really aware of why there are these different roles for the commission. I think it's just things evolved at different points in time, and that's what we ended up with. But this just shows you some of the couple of examples of how the responsibilities that we have differ. I won't really go into what the plans are unless anyone wants to talk about that. And then I think, as you're all aware, we have the 2 assessments going on right now. The SB 671 Clean Freight Corridor Efficiency Assessment, and now the state and local transportation needs assessment. SB 1121. Okay, next slide. And then, as you know, the commission is also responsible for approving various right-of-way matters. And so here it's not able to come up with an exhaustive list of the statutory references, but I listed some of the key ones. And these kind of are scattered throughout different parts of the code. But I'll just briefly highlight a couple. So obviously you're familiar with property condemnations. These are what we call the resolutions of necessity. The commission's role, and I think you've heard this at our meetings before, does not involve compensation for taking property. It's only very specific criteria, for example, if it is necessary and in public interest. These generally appear on our consent agenda unless the property owner is contesting it. We'll have a hearing and allow the property owner to speak and present their view. Sale of surplus property. This is when Caltrans determines property is no longer needed for transportation purposes. If the property was purchased with gas tax funds, which is usually the case, then the monies do have to stay within transportation. So they have to be put back into the state highway account. Relinquishments. This is when Caltrans is giving ownership of a portion of the state highway system, say a portion that runs through a local community. They're giving it over to the local agency. There's obviously an agreement between the two for that to happen. And the locals have to thenceforth thereafter maintain the route. But that's something that also comes before the commission. For relinquishments, there are also usually specific authorization in statute too to authorize this. I think I'll stop there unless anyone has any topics they want to discuss on right of way.
Maybe just one thing I'll add to the right of way. This is one of the places where we have a significant number of federal laws that overlay the state laws as well.
Okay, next slide. Okay, financing, we were talking about toll facilities earlier, and we just had one of those recently. So this is a relatively new authority for us, well, I guess about 10 years now. It was AB 194, which was enacted in 2014. We've only had 4 applications for tolling to date. And so the most recent one was for State Route 37. And we just went through that process, but just as a brief reminder, the statute has specific minimum eligibility criteria that agencies have to meet. Such as demonstrating cooperation between Caltrans and the regional agency, and that there's going to be improved mobility along the corridor. And then we also have guidelines that further require applicants to provide certain information to the commission. And as we were directed earlier this, well, yes, in May, we are going to work towards updating those guidelines in the near future.
Oh, you've got a question.
Yeah, Paul, I think this is something I'm focused on because Caltrans is now saying that as part of their sustainability, it's gonna come up tomorrow. That they're gonna talk about their sustainability plans, and one of the things they want to do is start working more about converting general purpose lanes into managed lanes. Those toll facility approvals, do they the Caltrans toll facility approvals come before us as well, even
Yeah.
if they may originate them?
Yeah, they can be either Caltrans or a regional agents.
Okay,
Yeah.
and is there any other layer? I mean, this is, I have bothered Vince Mamano every single meeting about what FHWA is doing about converting general purpose lanes to managed lanes, because that eliminates a step of going general purpose hot managed. So my question is, will there be a more truncated process? Because like I started, my very first meeting as a commissioner was on the 105 express lanes. And they're still not, I mean, that's 4 years ago. So are they gonna have a better, like, smoother process,
So
especially given
what
cap
those
time?
is, and I should have mentioned this. The applicant can come in for tolling authority very early. So in that case, they were not even through environmental.
Got it.
When they came to us. So that's why other ones like the San Mateo 101 lanes, they were basically on the verge of construction when they applied.
I
So
see.
those are already built and operational, but yeah, those is because they applied.
And what about Metro's congestion pricing, when you have cordon pricing and some of these other stratagems, do they come under us as well? I mean, because
There's-
they'll
I mean,
still
maybe-
include highways.
So the statute talks about corridors, and so it makes it seem like it's more sort of a, you know,
Anything with
managed
price?
lanes and those types of things, but I think there has been a
With the price.
question about
Oh,
whether congestion pricing may or may not fall under it. It's never been tested.
So should we have some preemptive conversations about it, since that's part of what CAPTI is identifying?
So, I think we should have some preemptive conversations, but I think we also have to recognize that how we talk about road charge versus pricing versus cordon pricing, it's going to really matter in the conversation of how we replace the one like gas tax. Because at the end of the day, we're talking to the public and we're talking to like the officials who are going to have to approve these things. And so we will have to get our messaging together to create a discussion that doesn't give the feeling of price at different points. But it is one price, and here it is, and this is what it is. So that when we're having that conversation with members of the legislature who will ultimately have to take the conversation from the public and the questions that the public may have, that they are very clearly informed on what it is and what the difference is between each of those different strategies that may be employed. I know there are a couple, I know there are a couple of pilot programs, or maybe there was legislation that maybe didn't pass, talking about cordon pricing.
Yeah, there's been some, I think, through legislation authorization for,
Or pilot programs.
yeah, I don't know.
I'm pretty sure none of them have actually been implemented
No.
yet to a place where they're actually pricing someone. We should-
So follow-up question.
Yep.
Almost called you chair.
And there is.
My first chair.
Oh,
But the distinction between a gas tax replacement and, let's say, a community wanted to do congestion pricing for local congestion. Would those both come to us, or just the road user charge portion?
So if we're replacing the gas tax, that would go through the legislature and probably a constitutional amendment, so it would not come before us. We would be the recipient of whatever came out of that process.
Yeah.
Yeah, we would be the recipient. Where you
Every
would
July
feel that
1st.
conversation though, that your stakeholders would be rallying each of you to say, here's what that means to us. Similar in a way that we saw that in SB1, right? Because we are kind of part of the voice of the message and the need statement about what's happening in transportation and what's happening in funding in that conversation. When we talk about cordon pricing, that's Paul's question of, it's never been tested. So we're not sure if it would come to us. We're not sure. The cordon pricing that's been approved so far has occurred through legislation. It has not pointed the agency to us in that legislation, correct, Paul?
Right.
But that's a question on AB 194.
Do we have a stance on it? Essentially, I think it's a question, so.
We do
it's
not,
worded
to my
as
knowledge,
opposed to
we do
the-
not have a stance at this point in time, an approved stance.
I have a follow-up question to your statement.
Let me write this down real quick, if you don't mind.
Okay. And that is, you made a statement about that there's some confusion about road charge, managed lanes, congestion pricing as potentially being, a charge upon a charge upon a charge. But this would be helpful, Joe, if you could maybe, because I thought the road charge is what we are gonna be paying just to get in a vehicle and use it, right? So that's just the price of freight, turn on your vehicle, you're gonna be paying something.
Yep.
maybe.
If you're driving on public
You're driving on
streets and
public roads,
roads.
Right. Pay to play,
So
right?
maybe one clarification. real quick. When I said it's confusing, I meant to the general public.
Yeah.
Right, and that's where it becomes really challenging when we start using very technical terms to describe something.
Okay, so I just want to follow up on this though, because you could essentially be paying, and we will, a road charge like we are now. We pay for road charges and we pay for managed lanes. And there's a scenario in which you could be paying for road charge, managed lanes, and if that scenario is also within a cordon, you could be paying all three.
Yes,
Okay,
yes.
Well,
Right
if
now-
San Diego and Hassan would have gotten his way, you would have been
Yeah.
paying a road charge upon a road charge.
yeah,
Yeah, so right now, for the average public, they don't break those costs up, right? They pay a toll, the gas tax, just they put it in the pump, they pay it, it's an unfelt fee
Mhm.
that they have gone used to.
Mhm.
As we start to transition, they're
Mhm.
going to recognize that there is a fee. And part of what we have to do in messaging, just like with SB1, we have to explain that that fee is needed, why it matters, how it helps them. Right, because we're talking about how does it help people?
Mhm.
And then we have to figure out how to make sure that they're not conflating everything to think it's something new,
Mhm.
right? Because it's gonna be a feeling, because like if I'm a travel demand modeler calls it an operating cost. Because it's the perception of the fee that determines how people drive or don't drive. Because in some cases you can feel the fee, right? When gas prices are high, gas tax hasn't actually changed, but it impacts how much people drive. And that perception of what the cost is to the consumer impacts the choices that they make.
And transit ridership soars usually when we have high gas prices.
Mhm. I appreciate this clarification. I know this is gonna be something we're gonna get asked about a lot, and not only in the commission meetings, but frankly in our Senate Rules Committee. And so this is really important clarification, and it's also as like add on top of that, communities that do or don't have yet, but want to, a self-help measure. I mean, there are lots of ways we're investing in infrastructure and we're getting benefits from it, but it seems as though people only are thinking about what they're paying into it and not what they're getting out of it. And so that cross messaging would be helpful as well.
Yeah, and they're also not thinking about the fact that they won't be paying a gas tax anymore. Right. And some people will be paying a little bit less and some people might be paying a little bit more, but.
Yeah.
It depends.
We people paying driving EVs.
You might be a little more.
Yeah.
Well,
My zero, it's gonna go up from my
Absolutely.
zero that I pay because I have a very old EV that pays nothing.
Right, this is a very large conversation. And we've seen it kind of play out with SB 1 again, right, is that. It is a brave step for a member of the legislature to make a vote. We've seen it in SB 1. We've seen what has happened to many members of the legislature for that vote. And so the more we can be proactive in that conversation, the more that we can work across all of our transportation agencies. Because messaging is going to be crucial to success. We don't want to be chasing the politics, because if we're in constant reaction mode, I will be honest, it is miserable for us all.
Mhm.
Well, I would think that Senate confirmation hearings would be an opportunity.
Have fun with that.
Yeah. You might think that. That's why we're trying to, lock down that message, because I think it is important, and we're not seeing this as just like, tax and spend, but it's essentially like how are we investing in what it
Replacing
is?
a tax.
What?
It's replacing a tax.
Exactly, and really, we're right sizing it. If
Mhm.
25% of the vehicles on the road are EVs and they're not paying in a similar manner to gas tax, that is not, as an EV driver, that's not equitable.
No.
And so we want everybody to
Paying
be
taxes on your electricity,
Yeah,
different taxes.
correct. But I mean, that's. It's exciting that CTC's been given SB 671 and SB 1121 to think of, and the road user charge to address this, and that's a big lift. When you think about like how that changes the entire framework of transportation, and so that respect, is warranted. And the reason why I want to talk about being on message with it is like, because we really, we've been given this respect as the honest brokers that we are. And so being clear is important. And so I just look, it's nice to have this opportunity while we're here in person to really get right with that.
Yeah.
So I
We're in a
appreciate
position
Tanisha, that you're
to-
leading that.
To know and to understand and see the future of this and the need for it and to pay attention to it. Everybody else in the world is not really, because there's so many other crises that they're
Right.
paying attention to. And so,
Can I
yeah.
maybe just give us a time check? So
Oh, wow.
we can, I don't mind
Fine.
continuing to have the conversation, but
Sorry.
I want to make sure that you all have a chance to at least grab your lunch if you want to do a working lunch and eat while we're having lunch to continue the conversation. So maybe if it's okay with you, we take maybe a 10-minute break to grab some lunch. Sorry, Paul, you're gonna be eating while you're talking.
No, I mean, I'm almost.
You don't
Well,
mind
it doesn't
dinner
mind.
theater, right?
I gotta take off, so I would actually prefer if we could finish up. If it is in the, in the
Yeah, there's
closing stages.
Really only.
It's only got one more.
slide.
But with this group,
Yeah. that's why it's- What words does the slide have on it?
Everybody else.
I did want to make one more point on the toll facility approvals, and we'll talk further about the Senate rules confirmation, but. There is a provision of the statute that, also another one that has not been tested yet, that has caused some confusion. So it says, nothing in the statute shall authorize or prohibit the conversion of any existing on-toll lane into a toll lane, except for HOV can be converted into HOT lanes. So that's caused a lot of questions about general lane conversions, since it says it's not authorized or prohibited. So we haven't, with State Road, with State Route 37, it wasn't an issue because for that project, we were authorizing pulling on the new lane. And then the existing lane was being converted to a parking lane, so it's clearly permissible. Okay, so moving on from polling really quick, Garvey bond financing also falls under the commission's purview. So these are bonds that can be issued that would be backed by future federal revenues. And the commission reports to the legislature by October each year. If it anticipates issuing Garvey bonds for the upcoming fiscal year. And that it would only hurt Caltrans or regional agencies indicated interest in having this financing mechanism. The state hasn't issued any Garvey bonds since 2008, so that was during the Great Recession when sort of the greater need, also given sort of the landscape of transportation funding at the time. Those bonds have been paid off, so there was some discussion during the COVID pandemic about possibly looking at Garvey bonds, but maybe there's a lot of federal money through, yeah, IIJ.
Has TIFIA kind of displaced Garvey at this point, or? Yep. I mean, in terms of usage, at least, or?
Garvey comes with a lot of strings attached to it. So Garvey, you're not gonna Garvey unless you have a good interest rate where it's going to be low. You know that you're going to bring forward your share for 12 years on the federal side. There's a lot of strings where TIFIA becomes a more viable option.
Yeah, beginning on the state level, having a adjudication over TIFIA.
I don't believe so.
Sorry, okay, and last point was the road charge technical advisory committee that we talked about with it. Again, it is advisory, as Tanisha mentioned, for a road charge to actually happen. The legislature has to enact it. No, the road charge tag is just, studying kind of like technical.
Well, it's also 2/3 vote.
Yeah, for the legislature. Okay, and the last slide,
So what was the 2/3 vote again?
If we're going to, if the state of California is going to establish a road user charge, it will take a 2/3 vote of the legislature and a signature by a governor.
So the last slide, so we can get to lunch and Commissioner has to do with our advisory role in statute. So the statute says the commission is to advise the secretary and the legislature on transportation planning and programming. As you know, we have an annual report that we're required to submit to the legislature. That's due each December. We are in that report supposed to summarize our prior year policy decisions, identify any timely or relevant transportation issues, and make recommendations. As far as we know, this is a somewhat unique role in state government. It's possible there's other boards and commissions that do this, but we're not aware of it. That's it. So any questions?
I have a question that is maybe so unrelated, but it's just, I don't know the answer. How do we relate to the Office of Traffic Safety? Do we relate at all? They pretty separate. Oh,
Well, we're separate. They're underneath CalSTA.
they're under CalSTA.
And as I mentioned at the beginning, we're also underneath CalSTA.
Right.
although
Sort of ish.
We also have independent authority.
Yeah, but they have no reporting role to the commission, OTS.
No.
No, okay. Thank you.
Thanks, Katie, even though you didn't get to do your presentations.
I think I have to ask if there's public comment, right? Is there any public comment? Babysitting Judy.
We have no one from the public.
Okay, thank you. This meeting's adjourned. Take our own.
Beautiful. No public to comment.